Hmm?
I think I can bring my laptop. Lectern.
I bet you can. Do the same one I do. Yeah. You can fold
Big one.
it.
I got the big one.
So you can treat it like a tablet if you want to.
Yeah, I was thinking that just make a big line. Thumbing through to find something to answer their questions probably takes longer than.
Just like pulling it open in a PDF. I know, that's what I did for our last trial. It's just like there's,
So I put everything that I might refer to in a oral argument resources folder.
okay.
That's got the brief attendance. It's kind of organized by cases cited in the brief. Those are all the cases.
Okay.
I don't know.
Okay. Smart.
Are they appearing via web?
Why not the district courts like this?
It's that fancy one.
Which commissioner? One time the commissioner was like, don't have cups of water for anyone. Because I declined and brought a little coffee cup and I got in trouble.
All present and quoted, please rise. Court of Appeals is now in session.
Good morning.
Good morning.
Welcome to the Utah Court of Appeals. I'm Judge Harris, and with me is Judge Orm, and on the screen, I hope you can see, is Judge Christensen Forster.
She's everywhere. You got her here, you got her there.
She's here, she's there.
Wow. Is she also here?
She is.
Amazing.
Anyway, so this is the first time I have participated in a hybrid argument like this. COVID has taught us a lot of things and has given us some technological capabilities we didn't used to have. So hopefully it will go well today, and please let us know if any of you all encounter technological problems throughout. The first case we're going to hear today is the case of Wadman versus Wadman. It's case number 20210513. If I could have the attorneys who are going to be making argument today state their appearances for the record, please.
Stephen Oliphant for Trisha Wadman, who's now known as Trisha Kennedy.
Good morning, Mr. Oliphant.
And Gabrielle Jones is to my left, but she will not be making argument today.
Okay, great. Good morning. Thank you.
Good morning, down to Dredge appearing for Ben Wadman, who is here in the court as well behind me.
All right, thank you. Good morning to you as well, Mr. Dredge. Okay, 15 minutes aside, my clock says 10 minutes. It looks like, I'm going to assume you've already communicated with the clerk about that. 5 minutes for rebuttal?
Yes,
Okay.
Your
Are
Honor.
there any other questions from you guys before we begin?
No, Your Honor.
Okay, well, we look forward to hearing your argument, and we'll turn the time over to you, Mr. Oliphant.
Thank you. Good morning, judges of the Court of Appeals. May it please the court. This appeal highlights case law that not only speaks to the importance of a child's right to child support, but also it provides instruction to the lower courts on how to protect this right for the children. The Utah Supreme Court stated in the Parker case, which was in 1997, the right of minor children to support cannot be bartered away, extinguished, stopped, or in any way defeated by the agreement or conduct of the parents. It is well established that every parent has the duty to support the children he has brought into the world, and this duty is inalienable. The Utah Child Support Act states every mother and father shall support their children. And then the act also defines what is a child. There are 3 definitions. The 3rd definition is what's relevant here, and that is a son or daughter of any age who is incapacitated from earning a living. In this case, there was no dispute that the child in this case, who's now in his 4th decade, he's in his 30s, is incapacitated. Even the lower court in its memorandum decision noted that there was no dispute and made that finding in that order.
And what's your position as to when, his name's Chase, right?
Chase.
When, I don't know whether to call him a child or an adult, it's this definitional thing that is at issue in the case, so I think I'll just refer to him as Chase, if that's okay with
Sure.
you. What's your position as to when Chase became incapacitated? I mean, I know there hasn't yet been a
Yes.
judicial determination of that, but what is your position?
Well, I do think there's been a judicial determination. The lower court acknowledged that the parties did not dispute there was an incapacitation.
Today, but I'm asking you what your position is as to when that incapacity began.
That's hard to say, because the record there's not a lot on the record about, because there's no dispute about this at any point. The parties got a divorce when the child, I think, turned 5 the month before the divorce. We know that the child was diagnosed as an infant for this disease. The parties did litigate a few years later when mother wanted to relocate to Alaska, and the parties submitted statements about the child's needs.
And yet the statute speaks in terms of incapacitated from making a living. We wouldn't expect a 5-year-old or a 12-year-old or a 16-year-old to be financially self-sufficient. So incapacity, specifically in the context of an inability to provide for one's own self, financially seems to be a rather specific inquiry.
Yes, and again, I think that inquiry is easily determined because the parties have essentially not disputed that
Well,
fact. That the
here's
child-
what I'm asking. Does it matter if the incapacity arose prior to the Chase turning 18 and or graduating from his high school class? What if, for instance, a hypothetical situation in which a child is perfectly functional at age 18, but at age 22 gets in a car accident and is rendered incapacitated at that point? Could somebody come back in at that point and ask for child support? In other words, does it matter does the child need to be incapacitated the whole time after age 18 or not? And number one, does that matter? And number two, if it matters, what's your position on whether Chase qualifies?
The short answer is no, I don't think it matters. I think the relevant inquiry is, at what point is the child a child as defined under the Act, right? So the moment that a parent or a guardian or the state who's seeking support, the moment that they have brought that issue to the court determines if that child is incapacitated at any age, then
Well-
they're a child and eligible for child support.
Not that we try to decide cases based on anecdote, but let me give you this situation. Here I am, fully self-sufficient, gainfully employed in this very job some 3 decades now. I'm in a bad accident tomorrow and am rendered incapacitated. No ability to work as a judge or anything else, serious brain damage and the rest. Is my 92-year-old father suddenly on the hook for child support because I am his child and I am at this point, in my hypothetical, I am now incapacitated, unable to make a living? At one point, he did in fact pay my mother child support with me in mind. But would he now have to cough up additional funds to help take care of me? Because I would be incapacitated at this point and I'm still his child.
Yes, under the statute, that meets the qualifications for a child that's eligible for child support. If your father or mother brought a petition requesting child support to aid in your support so that you are not a burden on the state or others, you would qualify as a child at that point because you are incapacitated at any age. So there is no exception in the statute about was the child not incapacitated at some point, even as a minor or an adult. An incapacitated child fits the definition of a child at any age under the statute.
It's like we
But
have-
that, oh, can you hear me?
Yes.
Yes.
Okay. Sorry, I've forgotten that we've been doing this for so long. But that seems sort of ridiculous to me. Judge Orm's hypothetical doesn't seem to be a fair reading of the statute in context of the whole child support statute. Doesn't it strike you that 78B 12-101-7 needs to be read in context with 78B 12-219, talking about emancipation? I mean, a parent is only required to support their child up till they are, become of age. So doesn't the emancipation / I'm no longer a child suggest that the inquiry needs to be made around the time a child turns 18 or graduates from high school?
Well, this issue was brought up in the Garand case. The parties received a decree, and so the appeal was addressing a modification. In the decree, the child was incapacitated. The decree awarded child support up to age 21, and then mom requested that it be extended. Dad claimed res judicata, that this had already been addressed, we'd already come to an agreement. The Supreme Court in that case went through the same analysis that the Dem Court did, that the Hibbins Court did, that the Ferguson Court did, addressing modifications, and said, every father and mother shall support their child, and this is a child as defined under the Act. And so they didn't even analyze the res judicata issue, they went straight to the fact that this child had the right to child support, even though there had already been a decree ending child support at 21. The court found that the child was still incapacitated and was still entitled to extend support beyond that time. I think that's an unusual issue that Your Honor raised because it wouldn't be in the context of a divorce and so on. But keep in mind.
Although at least we did have in my situation, my parents were in fact divorced. My father did in fact pay child support. Child support applicable to me ended when I turned 18. So there was that historical fact, but then, many decades of me being self-sufficient before, in my hypothetical, I'm rendered incapacitated.
One difference in that scenario is that the child in this case was always incapacitated as well.
But not as defined by the statute, where incapacitation is tied towards an ability to make a living. I mean, my 8-year-old, fortunately, no such infirmities as are at issue here, but was not in a position to be gainfully employed and become self-sufficient. Was not incapacitated by any means, doing very well in 4th grade or whatever that would be, and yet was, I guess, legally incapacitated in that she was not even legally entitled to go out and secure a job and make a living for herself.
What I heard you just say was sort of an answer to my question I asked a few minutes ago, which was, okay, first of all, does it matter when Chase became incapacitated? Your first answer is no, but I think your second answer is you think you could prove, if you had to, that Chase was incapacitated at age 18?
Yes, I believe so.
No, that's your position. You just said he's always been incapacitated. And so if the inquiry were a look back to what his situation was at age 18, you think you could show that if you had to?
Yes, I think that would show in this case. The record does reflect sort of progress and regression through the child's younger years, and I think at age 23, the record reflects that's when the seizures became even more worse and problematic for Chase.
And the briefs deal quite a bit with some success in school and up and down a little bit, some special ed assistance and so forth. Would the record tell us, did he at any point in time have a job?
The record would not reflect that. There was no mention of employment at any time.
The procedural posture of this case is you filed a petition that was dismissed on Rule 12b-6, so we don't have much of a record here, right? And so what you're saying is this petition shouldn't have been dismissed, at least not at this procedural stage. Let us go back and develop whatever record we might need to develop to show incapacity.
That's right. And again, I think the relevant, as far as a child support order that's going into effect now, retroactivity is one more other issue in this case. But now the child is incapacitated. Mom's position is the child's entitled to child support now, regardless of the level of incapacitation up to this point.
Yeah, retroactivity is actually kind of interesting here. I mean, you filed this as a petition to modify, presumably the modification angle here aimed at the amount? Because your position is the child support obligation never was lifted. So what here is being modified other than the amount, right?
Well, I also pled in the alternative to establish or to reestablish as well, as out of an abundance of caution, because I knew this was
Right, it's a little bit of an interesting thing because there hasn't yet been a finding of incapacity. So absent that, I don't know that Chase meets the definition of a child until you show incapacity. Now, there may not be a dispute about that once that's shown, but I guess I can see why the other side stopped paying child support absent that finding. But you're saying, well, I think I can establish that finding. Let's go make that finding. And once that finding is established, your position is child support then sort of springs back into being.
Yes, I think that would be permissible under the Utah law at this point. My time is up. If I could, there was one other issue of Judge Forster's question I'd like to answer, if I may.
Sure.
About the automatic adjustment. Even if the automatic adjustment, the court finds that does apply to an incapacitation situation, if the court runs through that the automatic adjustment statute, what it says is when a child turns 18, in this case we can run through this with Chase, Chase turns 18, then the child support is automatically adjusted to the children still due child support. And so even if we applied the automatic adjustment statute, Chase at that time was still incapacitated and still due child support because he is a child under the act.
And I understand that argument. It's just, it seems like we're chasing our tail a little bit because at that point in time, there hadn't yet been a finding of incapacity. Mm-hmm. And until that finding's made, he doesn't qualify under the statute, subsection C of the statute, right?
Right.
And so you're asking for that finding to be made now, and then the question of how that would sort of retroactively apply or not seems to be a whole nother gnarly issue in this case that isn't really, I don't think, presented to us yet, given that your petition was just dismissed on 12b-6. Mm-hmm. Is that the way you see it?
Yes, yeah. In another way to state it, yeah.
Okay.
I can rest, Your Honors.
All right. Thank you, Mr. Oliphant. Mr. Drage.
Good morning, Justices. May it please the court. I will pick up from that point in time, Your Honor, because the court will allow, if it reviews the record, to understand where the parties were to a limited extent at the time they entered into the decree of divorce in 1995, and then a petition to modify in 2002 shines some light on the scenario. This child was diagnosed with, I'm going to probably pronounce this incorrectly, tuberous sclerosis within a month of his birth. The child suffered from seizures. Through the child's life prior to divorce, there were medications, steroids, there was a surgery. So the parties knew at the time of the decree of divorce that their son had special circumstances and special needs. I think that's undisputed. And then in 2002, that's further underscored when the respondent at the time wanted to relocate to Alaska. My client filed a temporary restraining order, and within that, he indicated the child's medical needs, its monthly
So are you
follow-ups.
suggesting there's some kind of time limit or statute of limitations in which a parent needs to go and seek that finding of incapacity?
It's not necessarily a statute of limitation, it's provided within the code already. And I think the law and the case law I'll get into requires the parties and the litigants to present this to the court at the time they're going through the decree of divorce. The law is very clear.
Well, what if at that time they don't really understand the extent of the disease? Or to take a different hypothetical, what if a child gets into a car accident at age 17, decree of divorce was at age 5, and it's the car accident at age 17 that renders the child incapacitated? Aren't there situations where you wouldn't necessarily know the extent of the incapacity at the time of the decree?
Sure, arguably, yes. I mean, it's maybe not as offensive as the argument that, well, once the child's 32, and then you file a petition because there was a car accident, or 22, there was a car accident because the child is now outside the jurisdiction of the court. The district court maintains jurisdiction until that child emancipates. And so arguably at the age of 17, that might be a possibility, but that underscores my point. The parties did know this child had special needs more than any other child. And that was confirmed again in 2002 with the petition to modify filed by the respondent, where she goes through specifically a litany of the child's medical needs.
So you seem to be trying to tap into sort of equitable principles of things like waiver and latches and estoppel, right?
No.
Okay, so what legal principle are you tapping into then?
So this is the two controlling cases at the time in 1995 were the Jeffries case that was the Utah Court of Appeals in 88, and the Dem case that was in 1976. Both of those are similar to the case here. Both parties were going through a divorce. In those two cases, there were children that were incapacitated, that had special needs, and in both of those cases, the court extended child support beyond the age of 18. Now, in the Dem case, there were two girls that were incapacitated, could not care for themselves.
Well, okay, but my question, I suppose, is just because those cases did sort of have the foresight to deal with this in the decree. But just because that's the facts of those two cases, does it follow from that you have to do it that way?
Yes.
Is there anything in those cases that says so?
Well, so, yes, and let me reference back to the code, Your Honor, bootstraps on the definition of a child at the time of the decree of divorce. And that's where the Court of Appeals has said, at the time, we're gonna uphold this child support obligation, even though the code says.
Well, the automatic adjustment statute seems to contemplate a look at the definition of the child at the time they are allegedly emancipated, not at the time of the decree of divorce.
The way I interpret that is that in an ordinary divorce decree, in this case it's stipulated, there's an order of child support. That's what they bargained for. When the child turns 18 or graduates, that's when child support terminates automatically, whether there's one child or two children. It's done. And so with that automatic termination, which is directly on point with this case, it behooves the parties to litigate anything other or stipulate as to something that would control the child support beyond the age of 18, whether it's 18 to 21 or with the Jefferson Dems case, beyond the age of 21 because of the incapacity. And that's, with those two cases, that's where it's incumbent upon, and both these parties had attorneys, to understand the law at the time that this child is going to have special needs. And the law at the time provided that if there is a finding by the court at the time of the decree of divorce.
So you're saying at the age, and when Chase was 5 in 1995, these parties understood the extent of the disease enough to be able to predict the extent to which Chase would be able to make a living for himself 13 years later.
Maybe not make a living for himself. I think that would be a
Well, isn't that the
stretch.
statutory definition of incapacity?
It is, but it also, in reference to the case law, talks about special circumstances, or what I will use, special needs of a child. And so, but to underscore that point, in 2002, when Chase was still under the age of 18, there was a petition to modify solely based by the respondents on finances. And within that, she highlights Chase's issues at that point in time. Arguably, if she had an opportunity to modify, that would have been the time. I believe he was 12 or 11 at the time when that happened, and she goes through the litany of what special needs he has in a defense.
So I'm still struggling with the whole concept that Chase could lose the right to child support because of something his mother forgot to do in 2002, right? So can you talk to that a little bit about this whole notion that parents can't barter away their child's right to child support by stipulation?
We don't disagree with that, Your Honor. I think the Guerin case is on point in that regard, that you can't bargain away, but that's more towards waiver, and that applies to children under the age of 18. And that case dealt with a child under the age of 18, not with children that were older than that. And so they're not bargaining away. They stipulated to a decree with the child support amount based upon their child. Now,
That sounds like a bargain to me.
well, I mean, I guess at this point in time, are we gonna go back and renegotiate whatever the bargain was? They didn't waive child support. There's no estoppel, there's no waiver. The child received child support. Where the court is intimating is, well, is the child support necessarily at this time gonna go on in perpetuity, waiting for something to happen in the future? No, we know the constellation of facts at the time. And what's critical at this point is the Jeffries and the Dems case were controlling case law. They both had very good attorneys at the point in time. They sat down at the pretrial in October of 1995 and they bargained. They didn't waive child support, they didn't change child support. It was entered based upon, and the record will reflect this, the child support worksheets. And so they said, we're gonna waive alimony, we're gonna do this, we're gonna talk about this in distribution of the house, and when it comes to Chase, we're gonna have child support. Now, interesting, now this isn't directly on child support, but in the real property section of the decree of divorce, the court will find that they make reference to Chase, and that the equity in the house will be paid out when he reaches 18 or graduates. And so they bootstrap off of the child support code to the payment of the equity in the house to my client. And so there are a couple references. The findings of fact mirror the decree of divorce, saying you have bargained for this child support. Child support will be paid based upon the guidelines.
So in your view, if we're talking about a child under subsection C of the statute, a child who is of any age that is incapacitated, a parent could barter away that child's right to child support?
Not barter away. In this case, and I think this is where we're splitting hairs, they're not bartering away anything. There was a child support obligation. The parties could stipulate to at the time, and this would be better protocol, to child support being for a period of time beyond the age of 18.
What you're saying is these people agreed to only pay child support up through 18, and that's the deal they struck, and they should be held to it, right?
Because that conforms with the law at the time. And I think that's the consistency and the finality that people and litigants need. Because if the court says, okay, we've got an otherwise normal child through 18, and then we use the scenarios that both of you have presented, that then there is an accident or some infirm, that makes someone infirm and incapable of working at that point in time, whether it's 24 or 36, then that leaves the finality of a decree of divorce really not
Yeah, that
fundable.
seems like a different question to me, but what Mr. Oliphant tells me is that he thinks he can prove incapacity the whole time. He thinks he can prove incapacity as of age 18 or as of the date Chase walked down the aisle at graduation.
That would be after the fact.
And what's your position about whether Chase was incapacitated at that point in time?
The parents knew their child was incapacitated.
So you agree that Chase was incapacitated at age 18?
Right. I mean, I think the facts, based upon what's on the record, what they knew at the time of 1995, the decree of divorce, as well as in 2002, when the respondent filed the petition to modify, they knew his medical history. He had been suffering from seizures. He was actually subject to a medication study.
And so their failure to put that in the decree operates to eliminate Chase's right to child support.
Well, at some point in time, Chase's right to child support, are we saying that every child or every person, let's not use the word child, is entitled to child support beyond the age of 18, just in case something happens? There has to be that line in the sand based upon the case law and what the Utah code says. And the case law at the time interpreted Utah code to say that if the parties have a child with special needs, it is incumbent upon them to present that to the court. So when the decree is entered, the findings of fact support the judge's decision to say X, Y, and Z. In the Jeffries case, I believe that child was 37 years old when the divorce action happened. And the father argued, hey, she's 37, she's an adult. The mother argued, no, she's not, she can't work, she's incapacitated, she depends on me. And so at that point in time, the court said, I enter findings of unusual and special circumstances to support child support going on for this child's life. And the same, similar in the Dems case. There were two girls at that point in time when they went through a divorce, and they defined at the time. And I think that's the rub we're presenting to the court, is that at the time of the decree, if there are circumstances known, which in this case they were known, then the parents should demonstrate to the court so the court can enter findings to go beyond the age of 18. And they didn't. And can we go back and say that's unfair? I think ultimately we have to look at what the code provided at the time, what the case law provided at the time, and how the parties negotiated their case. There's child support. By operation of law, child support terminated. After that, it was 12 years before there was the filing of the petition to modify. And so when we relate back, now we're here 28 years later after the decree, arguing this to the court, let's go back and rewrite this decree of divorce based upon law that I think is very clear. When the court looks at 78B12-219, by operation of law, child support terminates when a child turns 18 or graduates from high school. Case laws.
And is automatically adjusted to what?
0 with one child. So I know it
What it
talks.
says, it's automatically adjusted for the remaining number of children.
Right.
So what's your response to Mr. Oliphant's argument that the remaining number of children remained 1 because Chase remained qualified as a child under subsection C of the statute?
If there was a qualifying, actually I'll use the term defining definition of that child prior to the entry of the order, or sometime before the child turned 18.
You lost me there, Mr. Drage. I mean, this statute, the statutory definition of child has included some version of subsection C for about 4 decades.
It does, but that's where Jeffries and Dems came in to say, at the time the decree is entered, that's where the parents define the child as being a child and incapacitated. That there was the judicial finding that is upheld by this court that says if you define at the time, we can go beyond. There was no definition. So for all straight up legal black and white purposes, this was a child as defined within the code, a normal child. Child support terminated at 18. Only after the fact is the respondent coming before the court to say, now I want to define the child for purposes of child support. Back to 1995, arguably, because the order hasn't been changed. So we want to go back 28 years and now change the decree of divorce and define that child as being incapacitated when they had all of that opportunity, arguably if there was a chance, before the child turned 18.
Judge Christensen Forster, did you have a question?
I'm sorry.
Well, I wanted you to address I think you kind of did, but I wanted you to address the Harris case, which was from 1978, that basically stands for the proposition that it recognizes that parents are only obligated to provide support to age 18, with the exception of parents of adult children who are mentally or physically incapable of caring for themselves. So I am wondering about your argument that child support automatically terminates at age 18 when there has been a judicial recognition that actually is not true, that the requirement of support still applies to adult children who are mentally and physically incapable of caring for themselves.
And just so we're clear, Your Honor, that's the Harris case, that's the 585P 2nd, 1978. That was a very brief opinion written by the court, and it dealt strictly, which I think is different in this case, an 18-year-old who was still in high school, and the court upheld the modification saying, well, this is a normal child, he's 18, hasn't graduated, but when he graduates, that's when child support would stop. So I think there was passive reference to incapacitation, but incapacitation was not in this particular case. And so that was the modification. That's what the opinion speaks to me, and I think is the law. It didn't deal with this particular circumstance. It just said, hey, and I think that's why the subsequent code was changed to the new Utah code, which says 18 or graduates from high school, because that legislative change occurred after that. So I think to clear up that issue, and that's what the Court of Appeals did at that point in time. Does that answer your question, Your Honor? I believe I've exhausted my 15 minutes unless the court has further questions.
I don't see any, so thank you, Mr.
Thank you, Your
Drage.
Honor.
All right, Mr. Oliphant, back to you for rebuttal.
I've heard in the argument that the father in this case is relying on the fact that this was something that was bargained for, even though that seems to be backtracked. It was definitely something the court pointed out in its memorandum decision, that potentially the parties bargained to terminate child support at age 18, even though there's nothing on the record to support that they actually did bargain that. In fact, this divorce decree contains no language as to when child support would end. Which is unusual. Typically, we do see divorce decrees that have the statutory language about emancipation.
Is that true, or might some parties in their council just choose to rely on the statute as the terminus? 18 or graduation from high school?
Yeah, and I can only speak to my experience as a family law practitioner. In general, we see the emancipation, the statutory language built into the divorce decree. That may be to make sure the parties have written notice in one document of how that functions.
Would it not also be the case, though, that in many divorces where there is a special needs child, that the possibility or the certainty that some support will continue beyond 18 or 21 is covered? When it's known, and apparently there's no dispute that it was known here, there's nothing one way or the other in the decree, but I think the judge's sense of it was that they at least knew about it and chose to say nothing particular, and in that sense perhaps bargained away, on the part of your client, bargained away the opportunity for the decree to extend child support beyond what the law would otherwise require.
Well, first, I may disagree with Your Honor. I don't think there's anything on the record here that would suggest that the judge in this case at the time of the decree was aware of any.
No, I meant the judge here.
Oh,
Looking
right.
back and reconstructing what might have happened, was aware that they both knew of the special circumstances of the child, and yet chose not to say anything in the decree, one way or the other. And in essence, this is, putting some words into his mouth, but in essence, their bargain was, we'll rely on the statutes to kick in when it's time for child support to be ended.
Well, I mean, that speaks directly to the case I cited at the beginning, that the parties, through agreement or conduct, and so that means if they're submitting to the divorce court a written stipulation with their signature, that's their agreement, or conduct, which could include failure to act, failure to bring that to the court's attention at that time. Again, this was a young child at the time. It's difficult for a parent, I became a parent since the filing of this appeal, to look at a child at a very young age and to say to yourself as a parent, my child is going to be incapacitated from earning a living. I'm not going to have every hope and dream and sacrifice to make sure that doesn't happen. That's a heavy burden to put on parents of a young child that maybe the reality of a reasonable person in that situation would say, yes, that child will be incapacitated. But a loving parent who's in that situation might not feel that that's something that they have to address now for a future event. Them turning 18 and still being incapacitated.
Well, your position isn't it, that parents can't barter that away?
And that's the Supreme Court's position as well.
And it seems like the other question, I guess, running around here is that if the parties in the decree chose to say nothing, we would then sort of default to statutory provisions for termination of child support, right?
If the decree would function like a normal decree, yeah, there'd be no finding
Right.
of incapacitation,
So
that's right.
we would look to the statutes and you've made your argument about what Section 219 means about automatic adjustment. I think your position is it never terminated.
The child was,
Because Chase never stopped being a child. Isn't that your position?
that's right. Now, there may be a statute of limitations issue. I know there's an 8-year one in the parentage code about bringing a request for child support, but that's for an initial child support order, not one that had already been existing. That's an issue that we never got to in the lower court.
Right, and exactly. So that may or may not be an issue, but that's not in front of us because this petition was dismissed on certain other grounds, not on that ground, right?
Correct. the fact that the parties may have bargained for this, which again, nothing on the record supports this. The Hills case was addressing the same thing, that there was a divorce based off of stipulation. And the Hills court stated, we cannot see how the incorporation of such a stipulation in a decree of the district court gives it any greater effect. And so reliance on the decree, just because there was some absence of mentioning of the incapacitation, does not prohibit a parent from bringing a request to modify. The Dem court was a modification case. It was represented, that was the initial divorce. That was a modification case. Most of the cases cited in my brief are modification cases where a parent is asking the court to extend child support after initial decree. Even the Garand case, the father said, we already dealt with this. The decree addressed child support up to 21 for our incapacitated child. Res judicata, the court didn't accept that and moved on. Unless the court has any further questions, I can rest.
Okay, I don't see any. Thank you,
Thank you,
Mr.
Your
Ruffin.
Honors.
Thank you, Mr. Drage.
Your Honor, do I have any time left or no? I wasn't quite sure.
No, you used it all up, and
Okay,
there generally aren't sir replies
Yeah,
at the
no, no,
Court of
that's fine.
Appeals. So
Thank you.
we appreciate the arguments made, and we'll consider the matter submitted. We'll take the case under advisement, as we almost always do, and we'll issue an opinion as soon as we're reasonably able to do so. Thank you for your arguments today.
Thank you, Justices.